Assalamualaikum everyone, welcome to another lecture by the Wakeel of London, and today the chapter that we're gonna cover is formalities. So, as it is previously established, in order to create a trust, in order to create specifically and express trust, you require three formalities: certainties, you require constitution, and then you require formality. Now, formality is basically the third requirement of an express trust. Okay, so you might as well know that equity looks at the intent rather than the form. This subtly just translates to that equity, there is no formality that equity requires. Okay, hence equity does not need any formalities, and equity will always look at the intent. Equity will try to dig between your intent rather than what is in front of it. Okay, but Parliament, the statute, enacted certain formalities for express trust because Parliament did not want to leave it just a very loophole-ish, because Parliament just came up with three reasons. Number one is basically a precautionary measure. Now, as you might as well know that proprietary rights are connected with the land even if the person dies. So, for example, if I say that I'm creating a trust in favor of you for this particular property, now if something goes bad, there's very serious circumstances are attached to it, right? So since we have established that proprietary rights are very serious and very valuable rights, hence there should be formalities pertaining around to it, as we know that trust is mainly linked with transferring of title, legal title, so it shouldn't be dealt with in a very formal way, right? And number two is so that one can avoid fraud. So another primary reason why the Parliament would have had enacted formalities for express trust is because when you have something in writing, it makes fraud very difficult to commit, as it is difficult to forge, because you can lie in court, that is relatively easier, but it is much more difficult to forge a fake document, right? Because you can get caught. An example is that the trustee can just say that trustee can easily, if there are no formalities, then the trustee can just say that no, this property belongs to me, the settlor has given the property to me and I'm not holding it in trust for you, right? So for that reason, you don't want anyone to just get away with it. And number three is to make, the most important reason in my opinion is so that to make administrative tasks easier. Why? Because when something is written again, it makes administration of trust relatively easier, especially as we know that trust can be created for a very long time until they are executed, or until legal title is transferred, and people can sometimes forget and die. So those gruesome events would not have any impact on the trust, and since there is a legal document. So guys, these are the 3 points that we covered in our very infamous chapter, formalities. Do leave your question and queries below. We're gonna cover the more of this topic very soon. Stay tuned. Previously, we discussed why the statute has enacted the formalities. We're going to move forward to part 1 of our chapter, which is what are the formalities for creating equitable interest. Okay, so there are certain form of trust, right? You can just ask us for a separate video of that. Let's not delve into that. Okay, so we're going to talk about formalities for creating equitable interest, and the first form of equitable interest is inter vivos trust. Now, this form of trust is usually created during the lifetime of the settlor or the testator. Now, the formalities differ. The formalities for inter vivos trust are very different. For movable properties, Y, and for immovable properties such as land. For movable properties, there are no formalities for inter vivos movable properties, and you only require the certainty of intention. However, for land, the statute under section 53(1) subsection B lays out certain formalities for immovable inter vivos trust. It requires that it must be evidence in writing and for it to be enforceable. The exception comes from Wakeel. We'll delve deep into that. Okay, so the general rule has emanated from the case of section 53(1)(b), which states any trust of land, for it to be enforceable, must be in evidence in writing. Statute uses the words manifested and proved, which means that there is an evidential requirement rather than a validity requirement. However, there is an exception to the general rule, which has come from the case of Wakeel versus Bosted, and the common law created this exception in relation to the statutory requirement of 53(1)(b). Now, this case states verbal trust of land is also enforceable in case there is fraud, right? So these are the requirement for your equitable interest. Now, this another form of equitable interest is your testamentary trust. Now, you must note very carefully that testamentary trust only comes into operation after the death of the settlor. The settlor is the one who is making the trust. Now, for testamentary, movable and immovable trust, you must always comply with section 9 of the Wills Act, which states that a testamentary disposition or testamentary trust must only be valid if it is in writing, has been signed by testator, countersigned by 2 witnesses in order to be valid. Now, we see that when we compare section 9 with our section 53, section 53 has a validity requirement. I mean, if you want it to be enforceable in court, it must be evidence in writing. However, section 9 states, section 9 has a validity requirement for the will to be valid. For the will to comply with section 9, it must meet the 3 very essential points. If either one of the points are missing, it's going to be declared void, as if the will did not exist at all. And if the will has been void, the property is going to go to the intestate successors. Intestate successors are those who receive the property in absence of a will. Now, we also further note that why is section 9 so strict. Section 9 is stricter because this will only comes into effect after your settlor has died. Hence, the settlor was the key evidence to hold the property in trust for the beneficiary. Hence, this will is going to come in effect after the death of one of the key witnesses. So the requirement is very, very strict. However, this guarantees some level of certainty and avoid commission of fraud, so witnesses have not committed any forgery. We studied that section 15 has an exception of Wakeel, where we established in section 53(1)(b) that for any trust of land to be enforceable in courts, it must be evidence in writing. But Wakeel came about. Wakeel is a common law exception. It said this case states that a verbal trust of land can be enforced if there is an evidence of fraud. And similarly, we do have an exception to section 9 of the Wills Act, which is secret trust, which means that even if the 3 requirements of section 9 are not fulfilled, this trust will still come into existence. Now, we further would like to tell you that secret trusts are a form of testamentary trust. This is just one category of section 9 of Wills Act. If you want to find more about the secret trust, stay tuned for the next video. Thank you and Allah Hafiz.